Before the former First Minister of Scotland, Alex Salmond, was acquitted of criminal charges regarding alleged molestation of women, he initiated and won a judicial review, a civil law process under Scots law, in which he challenged the Scottish Government, which was therefore in the role of respondent, to come up with their evidence against him. The following is a reading of the legal advice issued to the Scottish Government and discussed within the Scottish Government between September and December 2018. In other words, just after the accusations became public knowledge in August 2018. What I will read is all the legal advice and discussion thereof, which has been released by the Scottish Government as of today, the 8th of March 2021. As of this time, the final update to the release page was on the 5th of March 2021. That page is linked in the video description. As you listen to the following, bear in mind that there is currently controversy over whether or not any minutes were taken when the Scottish Government sought legal advice regarding this judicial review on two dates, the 2nd and the 13th of November 2018. The Scottish Government's current position to the committee of the Scottish Parliament that is investigating this matter is that on neither of those dates were minutes taken at all. Also of note is that the senior counsel for the Scottish Government, who we hear in the following notes increasingly expressing his exasperation and alarm at how his own client, the Scottish Government, has strung him along, is Roddy Dunlop, QC, or Queen's Counsel, and that since the time of this correspondence, from 2.5 years ago, Roddy Dunlop has been appointed Dean of the Faculty of Advocates. In North American terms, that would make him Chairman of the Trial Lawyers Association, and arguably, by that measure, the most accomplished legal adviser in Scotland, which is relevant to the current round of claims and counterclaims between Alex Salmond and Nicola Sturgeon, because Mr. Salmond's case is that Nicola Sturgeon, herself a qualified lawyer, insisted against Roddy Dunlop's advice that the Scottish Government should continue defending itself against Mr. Salmond's overwhelming case in the judicial review. In turn, Mr. Salmond contends that the Scottish Government actually knew fine well that it would lose the judicial review, as warned in the following documents by Mr. Dunlop at the time, and that the Scottish Government ploughed on, a term used in the correspondence, with this judicial review in order to let it be overshadowed by the criminal proceedings that then followed, in the hope that Mr. Salmond would be convicted on at least one charge, whereas, as it turned out, the jury acquitted Mr. Salmond on all 13 counts against him. Here begin the readings. 4th of September. Joint note by Senior and Junior Counsel for the respondents, that is the Scottish Government, in the petition of Alex Salmond, petitioner for judicial review. A consultation has been fixed for this afternoon, at which we anticipate discussing a number of matters, including the prospects of resisting permission for the petition to proceed. This note sets out our current thinking in advance of the consultation. Our view is that it is inevitable that the Court will grant permission to proceed. As set out below, it may be possible to attempt, at the permission stage, to exclude certain of the petitioner's grounds of review on the basis of time bar. It is a question for clients, the Scottish Government, whether they would wish to take the time bar points at the permission stage or raise them in answers lodged after permission is granted. The grant of permission will undoubtedly be reported both by the petitioner and the press as a victory for the petitioner, Salmond, and a defeat for the respondents, the Scottish Government. That reporting will likely be more emphatic if permission is contested, even on a limited basis. Equally, the sting can largely be taken out of any such report by the respondents, the Scottish Government, making it clear that a decision has been taken in the interests of expedition, getting things done quickly, and on the basis of legal advice, to concede permission and to focus on resisting the petition on its merits. The court may grant permission only if it is satisfied that the application has a real prospect of success. As clients are aware, the proper approach to that test was set out by the Inner House of the Court of Session in Whiteman 2018. Quote omitted. We think there is no prospect of a Lord Ordinary, a presiding judge in the matter, concluding that the petition does not have substance. The petitioner, Alex Salmond, advances 8 separate grounds of challenge to the procedure on the handling of harassment complaints involving current or former ministers, hereinafter the procedure, and to the application of the procedure in the petitioner's case. 1. Ultra vires, 2. Error of law, 3. Incompetency, 4. Procedural unfairness, 5. General irrationality, 6. Article 6 of the European Convention on Human Rights, 7. Legitimate expectation, irrationality and oppression in relation to allegation D, and 8. Privacy and confidentiality. While answers may be given to each of these grounds of challenge, we are certain that in the context of a permission hearing, the Lord Ordinary would be persuaded that there is sufficient substance in each ground of challenge to justify the granting of permission in respect of all of them. The Lord Ordinary will undoubtedly be influenced by the identity of the petitioner and the public interest in testing the lawfulness of the procedure and its application. Section omitted on time bar. We resume with the final paragraph of the advice on time bar. Given the low bar for permission, we anticipate that trying to argue time bar at the permission stage would simply hand the petitioner an easy win, as we imagine that he will be able to assert at least a case for an extension of time, and probably also an answer that time only started to run when the actual decision was made, which will at least pass muster for the purposes of permission. New section. We are asked whether there are prospects of having the Permanent Secretary, that is Leslie Evans, head of the Scottish Civil Service, dropped from the petition as a respondent in her own right. In our view, the Permanent Secretary is the appropriate respondent, so far as application of the procedure to the petitioner is concerned. The procedure confers on the Permanent Secretary a series of responsibilities in relation to the handling of complaints of harassment against ministers and former ministers. It is the Permanent Secretary, rather than a minister or the Scottish ministers collectively, who is required by the procedure to decide whether a complaint is well-founded. The Permanent Secretary is therefore the person who, in the language of the case West, has been given a power to decide, and whose decision-making is amenable to judicial review. That is not to say that the Permanent Secretary is the appropriate respondent in respect of all of the grounds of review relied upon by the petitioner. As we understand it, the procedure itself is the creation of the Scottish ministers in their role as employers of civil servants in Scotland, rather than of the Permanent Secretary, and any complaint about the vires, or powers, of the procedure is properly a matter for the second respondents. Clients, the Scottish Government, should consider whether the interests of the Permanent Secretary and of Scottish ministers are sufficiently aligned for there to be no need for separate instruction or representation, and to consider matters such as the extent of any indemnity for costs that might be offered to the Permanent Secretary. Comment: the lawyers here are hinting that if they are representing the Scottish ministers primarily, they cannot do right by Leslie Evans. New section. We have been asked for our views on whether the respondents should seek to have the judicial review proceedings sisted, Scots law term for suspended, pending the outcome of any police investigation and or criminal proceedings that may follow that investigation. In the week commencing on the 20th of August 2018, in the course of discussions about the extent to which the Permanent Secretary might publish information about the complaints against the petitioner, it became clear that the Crown Agent, an official at Scotland's prosecuting body, the Crown Office, was highly concerned about the risk of prejudicial pre-trial publicity that might arise if information about the complaints was put into the public domain. In particular, he was concerned about the risks arising from a combination of information that a referral had been made to the police and as to the findings made by the Permanent Secretary. The fact that matters have been referred to the police has been the subject of widespread reporting in the media. We are not aware of any reporting that discloses the Permanent Secretary's findings. We assume, but it can be confirmed, that the Crown Agent would remain concerned about the potential for information about the Permanent Secretary's findings to create a risk to a future trial. The petition narrates the Permanent Secretary's findings, and the decision report of the 21st of August has been lodged. It would seem to us impossible for a substantive hearing of the judicial review to take place without the findings and the contents of the decision report being discussed very fully. This risk of prejudicial pre-trial publicity could be addressed by sisting the petition proceedings until the criminal investigation is concluded, or imposition of sufficiently wide reporting restrictions in connection with the conduct of the petition proceedings. On the second option, clients may have concerns about endorsing a situation in which the petition for judicial review is effectively argued behind closed doors, given the concerns expressed earlier in the process about the need for transparency, and given the general public interest in the issues raised by this case. Equally, in relation to the first option, clients may not wish to be seen to be delaying the judicial review proceedings. However, the reasons for seeking to do so would, in our view, be likely to attract the sympathy of the court. We can also see strength in the argument that the criminal investigation may make the entire petition pointless. If there is a criminal conviction, then surely this case will not proceed, and if there is a trial and an acquittal, then the ministers would be faced with a very different situation than that which presently obtains. It would be helpful in this regard to have the views of the law officers of the Scottish Government. From the point of view of the criminal investigation, would they prefer this petition to be sisted? We have been asked for our views on the making of reporting restrictions. We consider that this issue should be considered more fully following further discussion of the pre-trial publicity issue set out above. Signed, Roddy Dunlop QC and Christine O'Neill, Solicitor Advocate. 17th of September. From the Lord Advocate to the First Minister, with copy to the Permanent Secretary. I have had the benefit of a consultation with senior and junior counsel to discuss a number of aspects of the case in light of a note prepared by the counsel. A copy of that note is attached. The following issues arise at this stage. A petition for judicial review may only proceed with the permission of the court. The question which arises is whether the Scottish Government should oppose permission, either in whole or in part. A decision is required in early course so that counsel can be instructed accordingly. Counsel advised that, subject to the point in the following paragraph about time bar, it is inevitable that the court will grant permission for the petition to proceed. Some of the arguments in the petition are arguably time barred. The rest of this paragraph is omitted. Although counsel consider it unlikely that the court would refuse permission on this ground, they would be willing to argue the point, and it is possible that the court would throw out significant parts of the petition, narrowing the focus of the dispute materially. This is the principal reason for taking the point at this stage. The principal arguments against taking the point are these: counsel's advice about the prospects of success, and any presentational concerns arising from failing in what might be perceived as an attempt to avoid parts of the case going forward to a full hearing. Whether or not the Scottish Government oppose permission, the grant of permission may no doubt be presented by the petitioner publicly as a victory. If the Scottish Government does not resist permission, that may be presented as a concession. The counter-narrative would be that the threshold for a case to be allowed to go forward is a low one, and the Scottish Government is unafraid to have its procedures fully tested in the courts. Counsel's advice is that both the Permanent Secretary and the Scottish Government are proper respondents. This is on the basis that, while the procedure is the Scottish Government's procedure, it gives a specific decision-making function to the Permanent Secretary. There is no need for separate representation, and the answers and the oral submissions should make clear that the Scottish Government is defending and standing firmly behind the Permanent Secretary's decision. Redacted sentence. The question arises as to how to minimise the potential impact of the reporting of these proceedings on any future criminal process. There are two potentially available mechanisms to that end. Assist, i.e. the petition is put on hold for a period of time to allow the criminal investigation to proceed, and reporting restrictions. I am satisfied that, if reporting restrictions are competent, these would adequately protect the public interest in any future criminal proceedings. On that basis, that would clearly be the preferable and appropriate route, since it would enable the issues raised by the petition to be addressed whilst protecting any future criminal process. Counsel has been asked to confirm that there is a proper basis for inviting the court to impose reporting restrictions. Assuming that Counsel is satisfied that there is such a basis, it is envisaged that an application would be made to the court to impose reporting restrictions in advance of answers being lodged on behalf of the Scottish Government. Signed, James Wolfe. Also written on the 17th of September was a note by Roddy Dunlop to the Scottish Government on the advisability of asking for reporting restrictions in this judicial review. The recording of that advice commences after the section on the Contempt of Court Act 1981. The principle of open justice is expressly protected by Article 6.1 of the European Convention on Human Rights, but is subject to qualifications that, quote, broadly reflect the various grounds on which exceptions to the principle of open justice are made in our domestic law, either under common law or under statute. Quotation taken from United Kingdom civil law jurisprudence. Other articles of the Convention may be relevant to any decision by a court to impose a reporting restriction, including Article 8. Where the rights of the individuals under inter alia Article 8 conflict with the right of the media under Article 10, a balance must be struck, and any restriction should be proportionate. The petitioner, Alex Salmond, seeks orders allowing the names of the complainers and the contents of the complaints made by them to be withheld from the public in the proceedings before the court. He also seeks an order in terms of Section 11 of the 1981 Act prohibiting any press or media reporting of the petition and all proceedings relating to it which would, in its own right or with other information, identify the complainers or disclose the content of their complaints. So far as the respondents, the Scottish Government, are concerned, there is a particular concern that any reporting of the findings of the Permanent Secretary in relation to the complaints may generate publicity that would create a risk to any future criminal proceedings. In our view, it would be appropriate for the respondents, the Scottish Government, to acquiesce in any application by the petitioner for orders that seek to protect the identity of the complainers. As we understand it, the complainers themselves have sought to protect their privacy and have been given assurances by the respondents that their anonymity would be preserved. So far as the nature of the complaints is concerned, clients have not expressed the view that the publication of that information would be likely to prejudice any subsequent criminal trial. Clients, the Scottish Government, may wish to remain neutral in relation to the reporting of the allegations themselves. It is, of course, the case that the most serious of the allegations has already been the subject of press coverage. Clients do have concerns about publication of the findings of the investigation, which findings are narrated in brief in the petition itself, as well as in the Permanent Secretary's final report. Restrictions on the reporting of the findings could be sought on the grounds that such restrictions are in the interests of justice, particularly by reference to the existence of ongoing police inquiries. It seems to us to be likely that there will be little difference between the parties as to what would be appropriate as regards reporting restrictions. Nevertheless, that does not mean that such restrictions will inevitably be granted. We say that for two reasons. Firstly, the court itself has an interest in ensuring open justice and will not automatically grant reporting restrictions even when both parties consent. Secondly, given the high-profile nature of this case, it is perhaps inevitable that certain media organisations will seek to make representations as to any reporting restrictions, as indeed happened in Anonymous versus the BBC itself, the case cited above. We make these points not to deter clients from seeking or acquiescing in such restrictions, but rather to warn in advance that this may not be entirely straightforward or unopposed. On timing, it would, in our view, make sense to discuss the timing of applications for reporting restrictions with those acting for the petitioner, in other words, Alex Salmond's lawyers. They have not yet moved for the reporting restrictions presaged in the petition, and it would be helpful to know if they intend to do so, and to indicate the extent to which the respondents, the Scottish Government, would acquiesce in any application made. Motions for the respondents could be enrolled at any time, but it would be desirable for them to be heard before the deadline, yet to be fixed, for lodging answers. Signed, Roddy Dunlop, Christine O'Neill. The following day, the 18th of September, Roddy Dunlop, on his own, wrote a brief supplementary note regarding the Lord Advocate's questions on the impact or otherwise of there not being active proceedings against Alex Salmond in terms of the criminal justice system. That note is not read here. 26th of September. Joint note by Senior and Junior Counsel for the respondents, Scottish Government. This note is a lengthy treatment of the merits of Alex Salmond's petition as judged by the other side's lawyers, i.e. the Scottish Government's lawyers writing the note. This is a point-by-point memo, and I shall read only paragraphs 6 and 7 from the initial summary. We think that there is a real risk that the court may be persuaded by the petitioner's, Mr. Salmond's, case in respect of the ground of challenge being based on procedural unfairness. This is a lengthy ground of challenge, attacking various aspects of the investigation process. We consider that the areas of greatest risk are in relation to the fact that witness statements and the initial report prepared by the investigating officer were not shared with the petitioner. A lawyerly way of saying that Alex Salmond was not given a chance to respond to the internal Scottish civil service procedure against him as former First Minister. The procedure does not provide for the sharing of such information with the Minister or former Minister who is the subject of the complaint. We should stress that we do see an answer to this point and consider the defence to be perfectly stateable, a valid case, for all the reasons outlined below. However, it would be wrong to pretend that we do not see a vulnerability in this regard. Equally, we should stress that the vulnerability arises from the procedure itself and not from its implementation in this particular case. Should the court be persuaded by one or more of the petitioner's grounds of challenge, it may make an order quashing the decision made by the Permanent Secretary. In other words, the court might strike out the internal Scottish civil service procedure against Alex Salmond as not fit for purpose. and requiring the Permanent Secretary to consider whether or not to order a fresh investigation. It is also possible that if the court considers that the procedure itself is flawed, that it quashes the procedure and requires the Scottish Government to consider whether to put in place a new procedure containing additional procedural requirements. If the procedure is quashed, then it is highly likely that the decision would also be quashed as flowing from a flawed procedure. The rest of this long memo is omitted. Signed, Roddy Dunlop, Christine O'Neill. Included in the disclosures is an email of the following day, the 27th of September, to the Scottish Government's lawyers by a redacted person at the Scottish Government, who evidently had not received the updated version of the previous day's memo as just read. The disclosed email indicates particular concern in the Scottish Government about Mr. Salmond's apparently robust case regarding the unfairness of the procedure launched against him by Leslie Evans and others in the Scottish Government. The email as disclosed reads, Christine, that is addressee Junior Counsel for the Scottish Government, many thanks for the note of prospects. I have now had a chance to consider its terms and I have discussed this with redacted. We anticipate that the one area where it would be helpful to have some further detail, in anticipation of being asked about it, is in respect of the area of risk you have identified on procedural unfairness. In particular, if the petitioner, Alex Salmond, is successful on this ground, what would the outcome be? I note from the pleas in law that he is seeking declarator and reduction of the decision. Scots legal terminology for a court declaring this civil service procedure to be null and void as not fit for purpose. What would this mean in practice? If the court declare the procedure to be flawed, would there be a legal consequence, or would this just have to be handled in terms of comms, etc.? It would be helpful to have your advice on this, and in particular, what is the worst case scenario, and is there anything we can do to mitigate or manage this? It would be extremely helpful if a paragraph or two could be added into the note of prospects to address these points. In response to this email, Christine O'Neill, Junior Counsel for the Scottish Government, responded that a new paragraph to that effect had already been included in the previous day's note. That paragraph was included in the reading of the previous day's memo just now. 30th of October. Email from Christine O'Neill to redacted recipient at the Scottish Government. Attached are further revised adjustments, making such changes in response to client comments as I think are appropriate. I have highlighted in yellow additional text about the conversations that the two complainers had with the Scottish Government before they made their formal complaints. The GDPR, data protection, issue remains outstanding. This email from the Scottish Government's lawyers was immediately forwarded around redacted and non-redacted recipients at the Scottish Government with the following comments. Dear all, please see the final adjusted answers. There remain 2 points outstanding. In answer 6, Christine and I have discussed the reference to the material about the discussions in November to address the call in respect of the complaint. The proposed answer distinguishes the initial complaint from the formal complaint in the adjusted petition by Alex Salmond. The call states, quote, the respondents are called upon to aver when, by what means and in what terms the complainers first initiated their complaints, whether those complaints were first made under and in terms of the procedure, when those complaints were first deemed to be formal complaints in terms of paragraph 10 of the procedure. End quote from Alex Salmond's legal challenge. Counsel for the Scottish Government are of the view that it is disingenuous not to refer to the first time the members of staff raised their concerns to members of staff. She has added in further wording to answer 6 to make clear that this is not the formal complaint. See highlighted in yellow. Second point outstanding, we still do not have a copy of the relevant privacy notice. Name redacted is trying to get to the bottom of this with name redacted. Please confirm by 3 p.m. that you are content. That is within 7 minutes of the email having been sent. Response to this by Liz Lloyd, Chief of Staff to First Minister Nicola Sturgeon. Redacted passage. Other than an additional "the" in the amendments in paragraph 9, I have no further comments. Signed, Elizabeth Lloyd, Chief of Staff to the First Minister. Further response from redacted to Scottish Government recipients, partly redacted. Redacted comments. Are you content, subject to Liz's comment below? Redacted comments. Response from redacted to the recipient group. Not quite. On answer 9 there is, as drafted, express mention of Judith Mackinnon. The procedure says that the person investigating should have had no prior involvement. Our view is that her role here didn't signal prior involvement. The matter is the substance of the complaint, and she wasn't in the organisation then. Need to be aware. And is there a need to name Gillian Russell, a senior Scottish civil servant, and Judith Mackinnon? Adding Judith Mackinnon onto the chain as well. She keeps dropping off. Need 5 minutes. Redacted comments. Another disclosure of an email from the same afternoon, the 30th of October, sets out what the Scottish Government's lawyers' concerns were at the Scottish Government's case at this stage. The pertinent detail from this disclosed correspondence by a redacted person at the Scottish Government concerns answer 6. It states, please remove the wording, quote, it explains inter alia that the first respondent asked Gillian Russell to act as a confidential sounding board for those who have experienced sexual harassment, whether current or in the past, end quote. Explanation continues, Ms. Russell is the second respondent's Director of Safer Communities. In other words, a director at the Scottish Civil Service who is in the management chain for the second respondent named in Mr. Salmond's Judicial Review Challenge. The text continues, Complainer A spoke to Gillian Russell on the 22nd of November 2017. Complainer B spoke to Judith Mackinnon, Deputy Director in the second respondent's People Directorate on the 7th of December 2017. 31st of October 2018. From Roddy Dunlop, Senior Legal Counsel for the Scottish Government, to redacted recipient at Scottish Government. Sent at 10:50 p.m. Marked Urgent Former First Minister Case. Redacted remarks. I know Christine, Junior Counsel, has raised a potential problem with you. I have just discussed this with the Lord Advocate, as I am very concerned indeed. He has suggested a short note setting out my concerns, and this is now attached. I'm sorry to be sending this to you at all, let alone late at night on Hallowe'en, but I'm afraid I see no other option. At Christine's suggestion, the distribution list is restricted for the time being to redacted and redacted. You will doubtless have to disseminate this more widely, but I prefer to leave it to you as to who should see it hereafter. Response sent to Roddy Dunlop at 11:27 p.m. the same evening, 31st of October, by redacted person at Scottish Government. Roddy, I had a useful discussion with Christine late afternoon in which we discussed these issues that redacted had raised with me at lunchtime. I spoke to key Scottish Government officials after discussing with redacted to get my own sense of the purpose of paragraph 10 and what was done in fact at the time in terms of ensuring a fair process. I understand that there is a note of discussion between the investigating officer, that is of the Scottish Civil Service, who first considered internally the complaints against the former First Minister Alex Salmond, and Complainer B, albeit I've not seen this yet. Christine read out to me the key parts. I had not understood that as being the first time the complaint was raised, but that can be checked. As you note, a clear understanding of the facts and purpose of paragraph 10 is vital, and I have, earlier this evening, commissioned a note, sought by close tomorrow, to inform the planned consultation on Friday, which I'm asking to be arranged per discussion with Christine. Your concerns are noted and understood, but, as you state, we need more information before assessing the import of these developments. In accordance with Scottish Government Legal Directorate protocols, that would of course involve advice from me to the Lord Advocate. In advance of the note so commissioned, I enclose an email from one of those involved in development of the policy about the purpose of paragraph 10. Redacted comments. The following reading is that urgent note by the Senior Counsel for the Scottish Government of the 31st of October 2018, referred to in the previous reading. Urgent note by Senior Counsel for the Scottish Government regarding Scottish Government procedural matter to Scottish Government Legal Directorate by email only. I refer to recent communications regarding this case in which various deadlines expire on Friday and in which a procedural hearing is fixed for Tuesday. My apologies for the hour at which this is sent and for recent difficulties in my availability. As I think is known, I, that is Roddy Dunlop QC, am presently engaged in a 3-week proof. By telephone call and email yesterday, the first standing junior of Mr. Dunlop's practice alerted me to a potential concern not hitherto known to either Ms. O'Neill, Junior Counsel for the Scottish Government in the matter, or myself. The concern arises in this way. By adjustments intimated on the 23rd of October, a week before this memo, the petitioner inserted the following call into the petition, that is, Alex Salmond included the following. The respondents are called upon to aver when, by what means, and in what terms the complainers first initiated their complaints, whether those complaints were first made under and in terms of the procedure, when those complaints were first deemed to be formal complaints in terms of paragraph 10 of the procedure, when and by what means the procedure was brought into effect, whether, and if so in what terms, the First Minister replied to the Note Production 7.7 of process, the relevance of the Fairness at Work 2018 document referred to in Answer 6 to the decision, and when and by what means the Fairness at Work 2018 document came into effect and was published on the second respondent's intranet. End quote of Mr. Salmond's challenge. At first blush, this appeared to be of no moment, writes Mr. Dunlop, other than perhaps to betray some sort of insinuation that the complainers had been encouraged to come forward. Nevertheless, Miss O'Neill, Junior Counsel, quite properly sought instructions on the issue. The concern that arises is that the answer to the question when, by what means, and in what terms the complainers first initiated their complaints is that complainer B, as I now understand the position, first made her complaint to Judith Mackinnon, Deputy Director of the People Directorate, in December 2017. That is of concern, because it was, of course, Ms. Mackinnon that was subsequently appointed as the investigating officer under the procedure which is presently under challenge. The reason why this is a concern is that the procedure says at paragraph 10, in the event that a formal complaint of harassment is received against a former minister, the Director of People will designate a senior civil servant as the investigating officer to deal with the complaint. That person will have had no prior involvement with any aspect of the matter being raised. End quote from the Scottish Civil Service procedure. I am told that it was thought that this did not present a problem to Ms. Mackinnon's appointment as investigating officer, as she had no prior involvement with the events giving rise to the complaint. I regret that I do not read the procedure in that way. Rather, I read the emphasised final sentence as stipulating that the investigating officer should have had, as the words themselves say, no prior involvement with any aspect of the matter being raised. The person to whom the first complaint was made, and who gave express advice to the complainer as to her options, including the possibility of making a formal complaint, has, as at the time of her appointment as investigating officer, had prior involvement with an aspect of the matter being raised, and a fairly fundamental aspect at that. Two questions arise from this. Do we have to disclose it? And if so, what effect will this have? As to the first, there is no real question. Arguments might be raised as to the extent to which the petitioner is entitled to detail as to how the complaints were made. But where, as here, the true facts give rise to a potential flaw in the entire procedure, there simply cannot be any question of not disclosing this. There may be judicial compulsion to answer the call, Mr. Salmond's legal challenge, and that would be extremely damaging. But even if there were not, there simply cannot be any question of lack of candour here. Accordingly, this point will require to be disclosed. As to the second, as presently advised, I consider that this presents a very real problem indeed. The petition is resisted on the basis that a fair procedure was instituted and then followed. In other words, that is the Scottish Government's legal argument in responding. If I am correct in the views expressed above, then the procedure was not followed. Rather, an express embargo, prohibition, was ignored in a way which may well vitiate, undo, the entire proceedings. In this latter regard, I understand that further information has been requested as to how it came about that Ms. Mackinnon was appointed as investigating officer. A final view on the repercussions will require to await receipt of that further information. But it would be wrong for me to suggest that this revelation is anything other than an extremely concerning one. I should stress, of course, that I am not suggesting bad faith on the part of anyone, least of all Ms. Mackinnon. But the fact remains that the procedure indicates, to my mind at least, that she was not eligible to be appointed as investigating officer. If I am right in that regard, then arguably that infects all that followed thereon. I understand that it is hoped that a consultation can take place on Friday after court, that is between the Scottish Government and its lawyers. That would be most welcome, especially given the procedural hearing next week. Hopefully, the further information mentioned above will be available in advance thereof. In the meantime, I should indicate that I was sufficiently concerned by the foregoing to contact the Lord Advocate, both to alert him and, frankly, as a sense check. He has suggested that this note be made available, and has also indicated that he shares both my firm advice that this issue will have to be disclosed and my concern as to the potential repercussions for the wider case. Depending on the information available on Friday, a swift decision is going to have to be taken thereafter as to whether the issue is disclosed and any argument based thereon then resisted, or the issue is disclosed and the petition then conceded, in other words, the Scottish Government gives up the case, as a result thereof. I can well understand the angst that even suggesting the latter will provoke, but if the proceedings are vitiated, undone, then it makes little sense to continue to defend the indefensible. There is a small upside to such an eventuality. The procedure would simply be reset, and safeguards could be put in place to minimise the risk of a further challenge to the renewed investigation. All of that is, however, presently hypothetical. A final decision will require to await the information discussed above. This note is simply provided to ensure that the main decision makers are fully cited in advance of Friday's consultation. Redacted remarks. Signed, Roddy Dunlop, QC. 2nd of November. consultation held between the Scottish Government and its lawyers. Ostensibly, no record kept. 3rd of November. Joint note by Senior and Junior Counsel for the respondents, the Scottish Government, in the petition of Alex Salmond, Petitioner for Judicial Review. Subject: Answer 6. That is, as drafted by the Scottish Government to submit to the Court in the Judicial Review. Further to discussions with clients over recent days, we set out in the annex to this note proposed adjustments to Answer 6 for consideration. The proposed adjustments are shown in bold underline. Clients will note that there are a number of matters on which further information/clarification is needed. See the footnotes to the adjustments. Clients may take the view, that is, the Scottish Government may take the view, that these adjustments are not sufficiently full in their terms. Please note that the pleadings are of course complemented by the documents that are referred to in the pleadings, and that will be before the court during any hearing. The court will not expect, and will not react kindly to, the repetition in the pleadings of the whole content of documents that are lodged. The permission of the court will be required for the adjustments to be allowed to form part of the respondent's written case. Permission will need to be sought at the procedural hearing on the 6th of November 2018. The court was advised on Friday the 2nd of November that the respondents could not yet confirm that they were ready to proceed to the substantive hearing on the 15th of January. Lord Pentland will expect to be addressed on the reasons for that. The adjustments can be intimated to the petitioner's legal team, Alex Salmond's lawyers, before or after the procedural hearing. The advantages of intimating them on Monday the 5th of November are that we would be in a position to advise Lord Pentland that this had been done, and indeed to lodge the adjustments in court on Tuesday morning, hence minimising the disruption to the court's timetable and any prejudice to the petitioner, and we would likely have an indication at the hearing of the petitioner's reaction to those adjustments. The second advantage may of course also be a disadvantage. The petitioner's counsel may criticise the respondents, the Scottish Government, at the hearing for the timing and the content of the adjustments, and may suggest that the adjustments contain important new and previously undisclosed information. The advantages of holding back intimation of adjustments until after the procedural hearing are that we would have additional time within which to finalise the terms of the adjustments, but likely no more than 2 or 3 days, and the petitioner's counsel would not be in a position to criticise the content of the adjustments at the procedural hearing. The petitioner will be given time to answer the adjustments. It is possible that they will also, in due course, seek the permission of the court to revise their note of argument to include material about this issue. Clients should be aware that the following are possibilities. The petitioner, Alex Salmond, may apply to the court for an order requiring disclosure of information relating to the process by which Ms A and Ms B first approached the Scottish Government and eventually made their formal complaints about the petitioner. If that order was granted, it would be necessary to disclose internal emails and notes concerning that issue. We have advised that there is certain material we have seen that might, if recovered, be used by the petitioner to attempt to impugn the integrity of the process. We note from the material provided to us today that in the informal discussions that took place with Ms A and Ms B in December 2017, they were given sight of the draft procedure, as it then was, for their views on whether it would have been a helpful process for them to have had access to in 2013. The petitioner might, if that was known, seek to argue that it was unfair that the complainers were invited to comment on the procedure at a time when they were considering making complaints that would be dealt with under that procedure. The petitioner may suggest to the court that evidence is needed to establish exactly what was done in terms of communications with the complainers between November 2017 and January 2018. It would be highly unusual, but we cannot rule out the possibility of the petitioner applying to the court for the evidence of the investigating officer and others to be taken orally in court. We would, of course, resist that. The investigating officer could provide an affidavit setting out what was done, and the petitioner has not advanced any alternative account of the background that would provide a foundation for cross-examining the investigating officer. We are aware that clients, the Scottish Government, will wish to understand the effect of this issue on our views of prospects of success. That cannot be realistically assessed until we see the reaction of the petitioner to the proposed adjustments. Signed, Roddy Dunlop and Christine O'Neill. In the annex appended to this note by the Scottish Government's lawyers, there are two, first a short and then a rather long, proposed amendments to the Scottish Government's Answer 6. The first of these proposed amendments has as its subject a staff message to all Scottish Government staff entitled Sexual Harassment Message from the Permanent Secretary, that being Leslie Evans, and the date of that message was the 2nd of November 2017. In this first proposed amendment of the text, the lawyers proposed the additional sentence, "It provided contact details for members of staff in the second respondent's HR function, together with information about sources of support." The second and longer proposed amendment by the lawyers is text concerning a further all-staff message sent by the Scottish Government dated the 13th of November 2017. That additional text reads as follows. In that message, she, that is the first respondent challenged by Alex Salmond in this judicial review, advised staff that the sources of support referred to in the message of the 2nd of November remained in place, and explained that, in addition, she had asked Gillian Russell to act as a confidential sounding board for individuals who had experienced sexual harassment. Ms. Russell is the second respondent's Director of Safer Communities, that is, Director for the second respondent in the Scottish Civil Service. On the 8th of November 2017, complainer B contacted Barbara Allison. Ms. Allison is the second respondent's Director of Communications, Ministerial Support and Facilities. Lawyers footnote at this point in the proposed addition, can we understand why Ms. B contacted Barbara Allison, given that she was not named specifically as a source of support in the messages issued by the Permanent Secretary? The lawyer's proposed additional text continues as follows. Complainer B discussed with Ms. Allison, blank inserted by lawyers. Footnote on that blank. We do not think we have information about what Ms. B discussed with Barbara Allison at that time. The lawyer's proposed additional text continues. She, complainer B, did not at that time make a formal complaint. On the 22nd of November 2017, complainer A spoke to Gillian Russell and Barbara Allison to discuss events involving the petitioner in redacted. She did not at that time make a formal complaint. Redacted. In addition, a number of members of staff of the second respondents approached Ms. Russell to discuss concerns about the behaviour of non-ministerial colleagues. Ms. Russell, with the consent of complainer A, shared the fact of the approach by complainer A and the nature of the information provided by her with the first respondent's Director of People, Nicola Richards, and Deputy Director of People Advice, Judith Mackinnon. Ms. Allison, with the consent of complainer B, shared the fact of the latter's approach and the nature of the information provided by complainer B with the same people. Ms. Richards advised Ms. Russell and Ms. Allison to ask complainers A and B respectively whether they wished to speak to the Human Resources team. Footnote by the lawyers. The note of the discussion with Judith Mackinnon of the 2nd of November 2018, that is at the time of drafting of this proposal, refers to emails to that effect being sent to Ms A and Ms B. We do not think we have those yet. The lawyer's proposed additional text ends, in December 2017, Ms Richards and Ms Mackinnon met with complainer A and Ms Mackinnon, redacted, to complainer B. In each case, the discussions concerned the options available to each complainer and their preference for how their concerns should be handled. Complainers A and B each indicated that they wished to reflect on what to do next. End of the Scottish Government's lawyer's proposed additions to the Scottish Government's Answer 6 to Alex Salmond's Judicial Review Challenge. 5th of November 2018, that is 2 days after the last item read, a joint note by the Senior and Junior Counsel for the Scottish Government was issued further to their note of the 3rd of November, containing the adjustments, in bold underline, precisely as just read out, but now without the 3 footnotes, pointedly asking the Scottish Government to supply further information lacking at that moment to the lawyers. 13th of November 2018. A further consultation was held between the Scottish Government and its lawyers. Ostensibly, no records were kept. 6th of December 2018. Email from Scottish Government's Junior Counsel Christine O'Neill to redacted recipients at the Scottish Government. Subject: Alex Salmond Petitioner, further note on prospects. I attach a further joint note on prospects dealing in particular with the issue raised about the prior involvement of the investigating officer. Clearly, our advice will not be welcome, and the contents of the note will be sensitive. I understand from our discussion on Tuesday, redacted, that you are likely to share this with the Lord Advocate before sharing more widely. It goes without saying that we would be happy to consult, and indeed think it would be sensible to do so sooner rather than later. Kind regards, Christine. Attachment: joint note by Senior and Junior Counsel for the respondents, Scottish Government, in the petition of Alex Salmond, Petitioner for Judicial Review, regarding prospects of success, that is, of the Scottish Government mounting a defence in the civil challenge or judicial review. In September, we gave our views on the merits of the petition and the prospects of successfully resisting this judicial review. Clients, the Scottish Government, also have Senior Counsel's note of the 31st of October 2018, which discussed the concerns that had arisen in light of the information then available about the investigating officer's prior involvement. The phrase prior involvement is in quotation marks because it is a phrase taken from the Scottish Civil Service procedure that is at issue. The investigating officer's prior involvement with complainers A and B in advance of their making formal complaints. Since then, there has been substantial further development of the pleadings, accompanied by disclosure of a volume of information about, among other things, the discussions that took place with complainers A and B prior to them making formal complaints. The disclosure of information was necessary, as can be seen from Lord Pentland's comments at the procedural hearing on the 6th of November regarding his expectations as to candour on the part of the respondents, although by then, of course, the need for candour had already been expressly recognised at consultation, that is, between the Scottish Government and its lawyers. New grounds of challenge have been introduced by the petitioner, Alex Salmond, based on the investigating officer's prior contact with the complainers. In our view, these are now the petitioner's strongest grounds of challenge. Moreover, and with regret, we are now jointly of the view that these grounds are more likely than not to succeed. At the outset, we recognise the dismay that this advice will cause. However, We feel it necessary to tender this advice and the reasons for it, given the views which we have, independently at first and now of consensus, taken in this regard. Paragraph 10 of the procedure, that is the Scottish Civil Service procedure that is at issue, provides that, quote, in the event that a formal complaint of harassment is received against a former minister, the Director of People will designate a senior civil servant as the investigating officer to deal with the complaint. That person will have had no prior involvement with any aspect of the matter being raised. The role of the investigating officer will be to undertake an impartial collection of the facts from the member of staff and any witnesses, and to prepare a report for the Permanent Secretary. The report will also be shared with the staff member. End quote. The key relevant facts are, in summary, on the 22nd of November 2017, Judith Mackinnon was one of the recipients of a note prepared by Gillian Russell, Director of Safer Communities, which described a meeting that Ms. Russell had had with complainer A, in which complainer A described the events involving the petitioner that were, in due course, the subject of the formal complaint. Ms. Russell's covering email explains that, I am looking to meet with 2 other people. One of those will relate to a similar set of circumstances. The other I do not know. End quote. On the 28th of November 2017, Judith Mackinnon was copied into an email to Gillian Russell and Barbara Allison, in which Nicky Richards asked Gillian Russell and Barbara Allison to contact the members of staff who had been in contact, quote, to check if they would be prepared to speak to us. The purpose of the conversation would not be to ask them to revisit statements already made, unless they wish to do so, but rather to respond to them on a more formal organisational footing. End quote. She also explained that, as part of the proposed discussion, quote, we'd like to share with them the developing policy for handling complaints against former and current ministers. This would give them an opportunity to test whether this would have helped them at the time, and also to explain the options open now. End quote. On the 5th of December 2017, Nicky Richards and Judith Mackinnon met with complainer A to discuss the options available to her. The details of her complaint were not discussed. On the 7th of December 2017, Judith Mackinnon had a telephone discussion with complainer B. The details of complainer B's potential complaint were not discussed. On the 8th of December 2017, Judith Mackinnon emailed complainer B, setting out options in relation to any formal complaint that might be made. In that email, the investigating officer, Judith Mackinnon, said, quote, as I mentioned earlier, there may be other individuals who are also prepared to submit a complaint. I would confirm to you if this is the case. End quote. On the 14th of December 2017, Judith Mackinnon was copied into an email to complainer A, in which Nicky Richards explained to complainer A that, we have now spoken to 2 other people who are also considering their position. End quote. Described further work that was being done to the draft policy, and suggested that complainer A take stock and make a decision in the new year on how to proceed. In relation to a formal complaint, the email concludes by saying that if there was a formal process, quote, it is likely that Judith would take the role of the senior officer, given she had no involvement at the time, and given her professional experience. End quote. In November and December 2017, Judith Mackinnon was copied into a variety of emails about the fact that individuals had raised informally concerns about harassment, about the provision of support to those individuals and how that should be managed, and about the development of the procedure for dealing with those complaints. Complainer A sent her formal complaint to Nicky Richards by email on the 16th of January 2018 at 12:19. By email of 12:46, half an hour later, Nicky Richards appointed Judith Mackinnon as the investigating officer and explained that she, Nicky Richards, had, quote, thanked Ms. A and said that you will be in touch. I have offered her my personal support should she need to contact someone. End quote. Complainer B sent her formal complaint direct to Judith Mackinnon by email on the 24th of January 2018. New heading: Non-compliance with the procedure. The petitioner, Alex Salmond, now avers that, quote, the appointment of the investigating officer was in contravention of the procedure, end quote, statement 2, and that, quote, prior to her appointment, the investigating officer, Ms. Mackinnon, had involvement and contacts with the complainers, end quote, statement 19, and in more detail, this is in Alex Salmond's statement 19, quote, the investigating officer's appointment was in contravention of paragraph 10 of the procedure. She was unsuitable for that appointment and was unable to perform her duties as investigating officer as a result of her duty to ensure the well-being of staff and of that involvement. The investigating officer acquired knowledge of the subject matter of the complaints and was party to discussions on how the complaints could be handled before her appointment was made. She gave advice to the complainers about how their complaints might be progressed and on how to respond if contacted by the petitioner or his solicitor. She was aware that the complainers were being offered encouragement to pursue formal complaints. The purpose of the relevant provision in paragraph 10 is to safeguard the fairness of the procedure, to ensure that the investigating officer's investigation is not tainted or compromised by the exchange of information between the investigating officer and the complainer or other persons, such as prospective witnesses and or the personal relationship formed between the investigating officer and complainers or other persons during the period before a formal complaint is made. The purpose of the relevant provision is also to avoid bias or the appearance of bias by the first respondent in the appointment of the investigating officer, or by the investigating officer in the performance of her duties. The first respondent and the investigating officer were under a duty to act in good faith and to comply with the requirements of paragraph 10 of the procedure. The first respondent and or Ms. Richards should not have appointed Ms. Mackinnon as investigating officer, and Ms. Mackinnon should not have accepted that appointment. That appointment was unlawful and unfair. Reference to a 2014 civil case. End of Alex Salmond's statement. After that quotation, the note from the Scottish Government's Counsel continues, aside from the reference to encouragement to pursue formal complaints, a characterisation with which one might take issue, we consider that these averments set out accurately the nature of the investigating officer's prior contact with the complainers. We also consider that the reasons they give for the inclusion of paragraph 10 in the procedure are compelling. Senior Counsel's note of the 31st of October sets out his initial views on the proper interpretation of paragraph 10, namely that the requirement that the investigating officer should have no prior involvement in any aspect, in quotes, of the matter, is a requirement that goes beyond simply ensuring that the investigating officer was not involved as a participant or a witness in any of the events that are the subject of the investigation. We remain of the view that this is the objective meaning of paragraph 10, and consider that it is highly likely that the court will take the same view. This arises as a matter of English language. It is underlined by the following sentence, which explains that, quote, the role of the investigating officer will be to undertake an impartial collection of the facts, end quote. In order to allow that to happen, it is necessary that she should, quote, have had no prior involvement with any aspect of the matter being raised, end quote. We can only describe what happened here as prior involvement. Accordingly, the investigating officer did not come to the matter fresh. Rather, her appointment followed discussions with the complainers in which options were discussed. One complainer was told that she would be advised if others came forward. And indeed, the terms of the not yet in force procedure were put to the complainers for their views. This is, we regret to advise, a substantial problem. We are conscious that the courts have held, in the employment context, that the prior involvement of a decision-maker and not merely that of an investigating officer, may be acceptable. We have referred in the supplementary note of argument to authorities to that effect, although, as can be seen from the decision in the case in question, the precise effect of such involvement turns on the precise factual context. The petitioner cites the Supreme Court's decision in Chabra. In that case, the National Health Service Trust, responding to Chabra, gave an undertaking to a psychiatrist employed by it that a colleague would play no part in the investigation of the psychiatrist's conduct. In the event, the externally appointed investigating officer shared a draft of her report with the colleague, and the latter suggested various damaging amendments to the report. The Supreme Court determined that the Trust was in breach of its undertaking to the psychiatrist. Quotation included, not read. The legal counsel note continues, the Supreme Court acknowledged that it was not the role of the courts to micromanage disciplinary proceedings between an employer and an employee. It also recognised that its decision that continuing with the disciplinary proceedings would be unlawful was the result of cumulative procedural failings and not simply the breach of undertaking. Nevertheless, that breach of undertaking was not a minor irregularity. In Chabra, the irregularity was characterised as a breach of contract on the part of the employer, and a similar approach has been taken in cases citing Chabra. That contractual relationship does not exist between the petitioner, Alex Salmond, and the Scottish Government. Nevertheless, we think it is inevitable that the court will accept that the petitioner had a legitimate expectation that the procedure would be followed. The respondents have, of course, with regard to other aspects of the petitioner's challenges, relied on the precise terms of the procedure. We cannot disavow the terms of paragraph 10. In light of the foregoing, there are two bases on which we consider that this aspect of the case is likely to see the petitioner prevailing, notwithstanding arguments that might be advanced based on such cases as Shiel. The first is that, unlike the situation in Shiel, where the previous involvement did not contravene any express prohibition, here the appointment was in clear breach of paragraph 10 of the procedure. That gives rise to a significant risk that the appointment itself will be held to be ultra vires. The stipulation in the procedure can be equiparated to the undertaking given in Chabra. The second is that in any event, the prior involvement here cannot be described as fleeting or de minimis, a legal term for not important. It was sufficient, in our view, to vitiate the appointment itself, a lawyer's way of saying that Judith Mackinnon should never have been appointed investigating officer. New heading: Apparent bias. The petitioner, Alex Salmond, also now pleads that the Permanent Secretary's decision was tainted by bias. Statement 4. In relation to the investigating officer, he pleads that, quotation from Alex Salmond begins, having regard to Ms Mackinnon's duty to ensure the well-being of staff, and her prior involvement with the complainers at a critical stage prior to the lodging of formal complaints, and the terms of paragraph 10 of the procedure, and the duties which she was expected to perform as investigating officer, and the failure to disclose that involvement to the petitioner, that appointment of Mackinnon as investigating officer would cause a fair-minded and informed observer to conclude that there was a real possibility of conscious or unconscious bias in and by virtue of that appointment. Having regard to the same considerations and to the fact that her reports were calculated to, and did, influence the first respondent's decision, as hereinafter condescended upon, the said observer would reach the same conclusion in respect of the performance of the investigating officer's duties and the content of her reports. Having regard to all these considerations, the said observer would reach the same conclusion in relation to the decision and the content of the decision report, that is, Ms Mackinnon's report. The quotation from Alex Salmond's argument ends with a citation of a relevant case from 2012. The memorandum continues, "The investigating officer was not a decision maker. She was responsible for preparing a report for the Permanent Secretary, who then applied her mind to the contents of that report. The question of apparent bias on the part of the Permanent Secretary is discussed below. There are conflicting authorities, that is legal sources, on the question of whether the requirements of procedural fairness, including the rule against bias, apply to those conducting investigations but who are not themselves decision makers. Such an investigator, according to a judicial review cited, quote, may be placed under such an obligation if the investigation is an integral and necessary part of a process which may terminate in action adverse to the interests of a person claiming to be heard before him." End quote. In the present case, however, we consider that there is little doubt that the requirement of independence will be found to exist, standing the express stipulation in the procedure, a legal turn of phrase for because of the express stipulation in the procedure, that, quote, the role of the investigating officer will be to undertake an impartial collection of the facts, end quote. In any event, we do not anticipate that clients would wish us to suggest that the investigating officer need not be impartial, but rather would wish to advance the case that the investigating officer was not affected by apparent bias. This is a lawyerly way of asking the Scottish Government, do you really want us to argue for you that there was no need for Judith Mackinnon to be impartial? The memorandum continues, if the court is persuaded that the appropriate test is whether a fair-minded and informed observer would conclude that there was a real possibility of bias on the part of the investigating officer, we think it is likely that the court would reach the view that the test had been met. We say that as a result of the full extent of the previous involvement as pled by the petitioner, Alex Salmond, and as evidenced by the documents now disclosed. We place particular stress in this regard on previous discussions and meetings with the complainers, on the fact that complainers were told in advance that it would be likely to be Judith Mackinnon who would be the investigating officer, on the fact that one complainer was told by Judith Mackinnon that she would advise if further complainers came forward, and on the fact that Judith Mackinnon wished to discuss the nascent procedure with the complainers before either the procedure was promulgated or the formal complaints were made. We stress that we do not suggest in any way actual bias on the part of Judith Mackinnon. On the contrary, we have no doubt that in actuality she performed her duties diligently, professionally, and impartially. But that is, of course, nothing to the point. If, as we think to be the case, objective impartiality needs to be demonstrated, then we do not consider that this can be said to be the case here. New heading. Apparent bias on the part of the Permanent Secretary. The petitioner's adjustments, that is Alex Salmond's new arguments, intimated yesterday, now include a direct attack on the Permanent Secretary's independence and impartiality. This had been foreshadowed in the pleadings, which attempted to tie the investigating officer to the Permanent Secretary. For example, averments that Judith Mackinnon and the Permanent Secretary were both involved in the development of the procedure, that the Permanent Secretary is Judith Mackinnon's line manager, which she is not, and that both the Permanent Secretary and Judith Mackinnon were aware prior to Christmas that approaches had been made by the complainers and support was being offered. That's a reference to Christmas 2017. The petitioner now avers in terms that the Permanent Secretary's prior knowledge about the existence of complaints, her involvement in the development of the procedure, and her knowledge of the potential appointment of Judith Mackinnon as investigating officer are such as to leave her decision tainted by apparent bias. On the basis of the information we have, we consider that this is a weaker line of attack than that which relates to the investigating officer. Conclusions. The question that will justifiably now be asked is where this takes us. There are only two options. One is to concede the petition, that is, to accept that the case is lost in the civil proceedings, and, if so advised, return to square one. We have no doubt whatsoever that this is not an attractive option. It would require the conceding of, doubtless substantial, expenses, and would be trumpeted everywhere by the petitioner. The other is simply to press on regardless. That is, in many ways, even less attractive. The expenses will be far higher, and the trumpeting far louder, if the case proceeds to a written judgment. Moreover, and potentially of more concern, is the real prospect of damaging criticism from Lord Pentland. He is not a judge known to pull his punches, and we are both concerned at the possibility of criticism, both from the bench, in the course of the hearing, and in any written judgment, which would not reflect well on the respondents, the Scottish Government. Ultimately, our own view is that the least worst option would be to concede the petition, that is, to give up the civil case. We understand how unpalatable that advice will be, and we do not tender it lightly. But we cannot let the respondents, the Scottish Government, sail forth into January's hearing without the now very real risks of doing so being crystal clear to all concerned. Signed, Roddy Dunlop and Christine O'Neill. The same day, the 6th of December 2018, a redacted individual at the Scottish Government forwarded this note to the Lord Advocate, the Scottish Government's Chief Law Officer, with the following comments. Lord Advocate, please find attached a joint note of prospects just received from Counsel. In summary, due to the prior involvement of the investigating officer, their advice is that there are two options going forward. Concede the petition, and if so advised, return to square one, or press on regardless. Counsel are of the view that the least worst option would be to concede the petition, that is, give up the case. They understand how unpalatable that advice will be, and they do not tender it lightly. Should you wish to consult, Counsel will be available to do so in the course of Monday afternoon. Please note that, as yet, redacted has not had the chance to consider this note, and it will not be circulated more widely until we have had the opportunity for your views on the matter. This note on prospects was responded to the same night at midnight 53 minutes on the 7th of December 2018 by the Scottish Government's Deputy Solicitor, Paul Caquette. He wrote, Christine and Roddy, thank you for your two emails of the 6th of December and your note on prospects. I'm sorry that our best laid plans, discussed with Christine on Tuesday, for managing the flow of information in a measured way through myself, have gone awry, and that the Lord Advocate, the First Minister and the Permanent Secretary have all, in the course of Thursday, seen your note. That being the case may impact on arrangements for the planned consultation, on which others will be in touch in the course of Friday, as redacted will be too in respect of certain aspects of procedural matters which should, so far as possible, continue to be progressed, pending the chance to consult and reach views thereafter on the way forward. I met with the Permanent Secretary, Leslie Evans, on Thursday afternoon to discuss your note. Aside from some issues relating to practical arrangements for the consultation and matters concerning affidavit evidence, that I will pick up with you once further thought has been given to certain aspects, the actions I've been asked to pursue from that discussion with the Permanent Secretary are to ascertain the basis on which Counsel felt the need to issue their note at this point. I have consistently stressed to her and others the importance of our understanding the views and concerns of Counsel, and that it is right that Counsel are clear to and with us about the weaknesses of our case as well as the strengths. But the Permanent Secretary, having been aware of these concerns from the previous notes, the meeting with the First Minister, other advice from the Scottish Government's Legal Directorate, and on her own consideration of the matters, and being fully cited on the options that arise from these concerns and that advice, is unclear, in effect, about what has changed since the last notes and First Minister meeting that leads you to write as you do. I understand that the First Minister has the same question. This may be that concerns derive from your deeper consideration of the relevant case law, or it might be in light of the latest adjustments bringing the Permanent Secretary in, though, like us, you reach the view that these additional adjustments are a weaker line of attack. I've been asked to seek clarification from you on that issue in light of what we already knew. And secondly, this being the second thing that Leslie Evans wanted Paul Caquette to raise with the Scottish Government's legal counsel, linked with that, the point was made to me that, while the note is clear about the case against us and its force, it is less clear about what our counter-arguments would be on the key issues if we elected to proceed. This can be explored when we consult, but the Permanent Secretary is keen to see and understand how Counsel would capture and express those counter-arguments. This may be a task for all of us to work on over the days ahead, but is an issue she is keen to understand better. Such information is important in considering the options available, whether the two set out, or additionally, options in proceeding with use of affidavit or oral evidence, covered in Christine's second email. One specific aspect of that, of particular importance to the Permanent Secretary, is your assessment of the material previously provided to them on other analogous HR practice in other similar, if not identical, circumstances, and how we can deploy that, and our interpretation of what was meant and done in respect of paragraph 10 of the procedure, as set out in previous papers. Again, cross-compared not with case law, which she appreciates is for you, but with such analogous HR practice in other similar circumstances. Signed, Paul. A response was issued the same morning, Friday the 7th of December 2018, at 10 minutes past 8, by Roddy Dunlop, QC. Paul, this one falls to me to answer. The issuing of the note was at my insistence. I addressed the queries raised as follows. To ascertain the basis on which Counsel felt the need to issue their note at this point, I had not seen the whole correspondence, or precisely what the petitioner, Alex Salmond, would make of it when we last met. Substantial further documentation has since then been made available. It leads me to the conclusions discussed in the note. The concerns I expressed at the conference with the First Minister have deepened in light of the documents now disclosed. I discussed my concerns in light of the material as a whole with Christine last week. I had previously indicated that an updated note on prospects would be required once the full picture was available, and this is it. Given the imminence of the hearing, I did not think it sensible to delay the communication of my concerns. Linked with that, the point was made to me, this is citing Paul Caquette, that while the note is clear about the case against us and its force, it is less clear about what our counter-arguments would be on the key issues if we elected to proceed. Response: the problem in this regard is the lack of arguments, hence my concerns. The only options are to argue either no breach or breach but its effect does not vitiate. For the reasons given in the note, I doubt either will work. The former is probably unstateable, no breach. The latter faces the problems identified in the note. I am further concerned that any defence might expose the risk of individuals being forced to give evidence. I do not think that in anyone's best interest, but that is a subsidiary concern. Further citation from Paul Caquette's memo. Your assessment of the material previously provided to them on other analogous HR practice in other similar, if not identical, circumstances and how we can deploy that. Response: this does not alter my views. The respondent's case, the Scottish Government's case, stands or falls on the procedure, the civil service procedure. If it was not followed, we have a problem. Other cases which have not been litigated either have different procedures, have procedures which have been followed, or have procedures which haven't been followed but haven't been challenged. None of that creates a precedent in law on which we can rely. Final citation of Paul Caquette. Our interpretation of what was meant and done in respect of paragraph 10 of the procedure, as set out in previous papers, again cross-compared not with case law, but with such analogous HR practice in other similar circumstances. Response: this has been explained previously. In short, the actual intent behind paragraph 10 is irrelevant. As with any utterance, it will be construed objectively. The objective, ordinary use of English indicates that Judith Mackinnon had prior involvement, and that meaning is underlined by the following sentence in paragraph 10 and its emphasis on impartiality. Signed, Roddy Dunlop, QC. 11th of December. An email sent from a redacted person at the Scottish Government to several recipients in the Scottish Government, including the Director of Communications, Ministerial Support and Facilities, Nicola Richards, and Liz Lloyd, Chief of Staff to the First Minister Nicola Sturgeon. Subject line: Update from Lord Advocate and Solicitor-General meeting. In other words, a meeting between the Scottish Government's Counsel, Mr Dunlop, and those two senior law officers of the Scottish Government. The first paragraph of the email makes clear that the writer of the email got this as a readout from someone who attended the meeting. And the email continues: Meeting went well, lasted an hour and 3/4. The Lord Advocate and Solicitor-General were very clear that there was no question or need to drop the case. The Lord Advocate was clear that even if prospects are not certain, it is important that our case is heard. Senior Counsel made clear that his note was not intended to convey that he didn't think we had a stateable case. They tested most of the arguments, including the appointment of the investigating officer, and concluded that we have credible arguments to make across the petition, meaning on all points of Mr Salmond's challenge. The argument on the appointment of the investigating officer will turn on the extent to which we can persuade the court that there is a credible alternative to the objective reading test of paragraph 10 of the procedure, which is that what we had in mind was that the investigating officer should not have had any prior involvement in the matters under investigation, i.e. the events being complained about. Nicky's, that is Nicky Richards' affidavit will be key to that. Discussion about Judith's, that is Judith Mackinnon's affidavit, concluded that it should be finalised and submitted to demonstrate what her role actually amounted to, and that her contact didn't result in bias or the impression of bias. Redacted will be able to elaborate on that and put the wheels in motion. Counsel followed up the question of what the Permanent Secretary knew about the approaches from staff by late November. This will mean late November 2017, just before the formal complaints were lodged. While we are clear that there isn't a procedural bar to her knowing the detail at any point, they, that is Mr Salmond's team, are constructing an argument to the effect that early exposure to the detail resulted in her being predisposed to find against Alex Salmond. The paperwork doesn't shed much light on that. My understanding from Nicky Richards and Barbara Allison is that she had been told that approaches had been made on the back of her staff messages. They concerned Mr Salmond, and they related to sexual harassment, but with little or no further detail. Counsel have asked us to confirm what, if anything, she was told beyond that. I'll follow that up with the Permanent Secretary today. Some thought was being given to whether an affidavit from the Permanent Secretary, Leslie Evans, was needed to address the point. I think, redacted, was less convinced than others that that would be helpful or necessary. Redacted, and I will talk to the Permanent Secretary today. Redacted section. End of readout. In response, the same morning, a redacted person at the Scottish Government replied to a group of Scottish Government recipients, "Thanks. This is a fair summary. The Lord Advocate was indeed clear about no question of conceding, with a stress on the benefit that would accrue from a judicial finding that it was right to have a procedure in such circumstances, and that it was right to have this procedure, even if there is a risk, which we all know and understand, that he may be forced to hold that there were faults in the way it was applied in the particular case." I would just add that the sense of how this would play out is that there are two distinct strands of this issue: the objective meaning of paragraph 10 of the procedure, and the suggestion of apparent bias in the role of the investigating officer on whether, in the circumstances of her role and level of engagement, it was not possible for there to be an impartial gathering of the facts by her, in the eyes of a reasonable and objective observer. An hour later, that same response to the readout was forwarded to include Sarah Davidson, the Scottish Government's Director General for Organisational Development and Operations, who has since left the Scottish Government. In the half-dozen remaining disclosed documents from the rest of December 2018, Sarah Davidson becomes an increasingly major player in the Scottish Government's considering of its position in the legal case as matters turn to the use of taxpayers' resources. The next 3 items of disclosure, within the space of 4 days, are all notes from the Scottish Government's Counsel to the Scottish Government, and show increasing dismay by the Scottish Government's lawyers. 16th of December. This note deals with practical matters that require to be dealt with in early course in relation to the disclosure of documents and further adjustment. That is, of the Scottish Government's written position in the case. Disclosure of documents. The petitioner's motion for commission and diligence, that is, Alex Salmond's motion for the Scots law term equivalent to discovery in US law, was granted on the 14th of December, that is 2 days before this note. Morag Ross, QC, has been appointed as Commissioner, that is, overseeing the discovery process. In discussions with Lord Pentland at the hearing on the specification, Counsel for the petitioner, Alex Salmond's lawyer, was not entirely clear about whether the petitioner would insist on holding an open commission. It may be possible to avoid such a commission taking place, but clients, the Scottish Government, should proceed on the assumption that a commission will take place in the course of the week of the 17th of December. If a commission or discovery process is to take place, it will be open to the petitioner to cite persons thought to be the havers of relevant documents. Scott's legal expression for subpoena those thought to be in possession of relevant documents. That includes the Permanent Secretary, Leslie Evans, who is a respondent to the petition in her own right. The availability of the Permanent Secretary and of the other persons most likely to be cited as havers in the possession of documents, namely Judith Mackinnon, Gillian Russell, Barbara Allison and redacted, should be checked as soon as possible, and they should be advised of the possibility of being cited. We understand that Nicky Richards is abroad until the 8th of January. It was suggested to the petitioner's counsel, Alex Salmond's lawyer, that redacted may be the appropriate person to cite to speak to the searches that have been undertaken, and it remains to be seen whether the petitioner's agents would be satisfied that he can speak for the respondents on this matter. Searches undertaken. We, that is the Scottish Government's lawyers, have an email from redacted of 1822 on Thursday the 13th of December describing the process that was undertaken of searching for documents. That email describes in general terms what was done and refers to work done by Scottish Government officials. If a commission, or discovery process is to be avoided, it will be necessary to provide the petitioner's agents, Mr. Salmond's team, with a more detailed explanation of what has taken place. Who has undertaken searches? Each person who has done so should be identified, including the Permanent Secretary herself. Has each person had sight of the specification of documents? Has it been explained to them by a solicitor? What searches has each of them undertaken? Chapter and verse is needed in relation to hard copy and electronic documents, emails, etc. Barbara Allison has produced text messages. Are there any other relevant text messages about the development of the procedure, or about the complaints of Ms. A and Ms. B? From discussions with the petitioner's counsel, Alex Salmond's lawyers, it seems inevitable that further questions will be asked about social media applications, including, for example, WhatsApp. This work needs to be done immediately, with a view to providing a comprehensive explanation to the petitioner's agents early in the week, and in the hope of avoiding the need for a formal commission or discovery process. New heading: Signature of a certificate. At the end of last week, there was discussion about the possibility of Sarah Davidson signing a certificate confirming that, to the best of her knowledge, all relevant material has been disclosed. Such a certificate may or may not now satisfy the petitioner, but if it can be given, we can see no reason not to give it. Ms. Davidson should, however, be given advice about the implications of signing such a certificate and the need for her to be satisfied as to the searches that have been undertaken. New heading: Adjustments, meaning to the Scottish Government's written case. We do not consider that the respondents' pleadings, that is the Scottish Government's pleadings, are as full as they could or should be on the knowledge and involvement of the Permanent Secretary, Leslie Evans, in the development of the procedure, and in the handling of the complainers' concerns prior to formal complaints having been made. We had understood that a full precognition, the Scots law process of having sworn testimony from witnesses as to what they will say before the court hears their evidence, would be taken by reference to the various documents that have been disclosed and lodged, and that involve the Permanent Secretary sending or receiving emails and other documents. The document we received on Thursday the 13th of December, and which sets out the Permanent Secretary's position, is not sufficient. It states, for example, that, quote, "I knew that some of those contacting senior staff had expressed concerns about the conduct of the former First Minister Alex Salmond, and that those concerns appeared sufficiently serious to warrant concern and might lead to formal complaints." End quote. We are not told how the Permanent Secretary came to know that, or indeed how much she knew about the seriousness of the complaints. It also does not deal with what she knew about Judith Mackinnon's involvement in the management of complaints. It refers to Nicky Richards and Barbara Allison, but not to Gillian Russell, who was the recipient of a request from the Permanent Secretary to act as a person to whom staff members could come forward. We would wish to have a full precognition as soon as possible, dealing comprehensively with the Permanent Secretary's involvement and knowledge. We ask for this not with a view to lodging an affidavit, but to enable us to respond fully to the petitioner's averments. Alex Salmond's statements. That should be done at an early stage to avoid further criticism from the petitioner. Signed, Roddy Dunlop and Christine O'Neill. 17th of December. We have drafted this note for the eyes of the Lord Advocate and Paul Caquette, Deputy Solicitor for the Scottish Government, only. It has been prepared in response to a series of events in the week of the 10th of December which led us to consider very seriously whether we were bound to withdraw from acting for the respondents in this matter, meaning to stop acting for the Scottish Government. Having given the question anxious consideration, we concluded that we would be entitled to so withdraw, but at this stage are not bound to do so. We introduce matters in this way to convey the seriousness of matters from our perspective. It is a matter for the recipients of this note to decide on its wider circulation, but our own preference is that the note itself is not circulated more widely. We would wish to avoid damaging working relations with the wider Scottish Government Legal Directorate and the Scottish Government team involved in instructing us. We also do not wish to add to any perception there may be that we are not committed to the case. We have prepared a separate note dealing with practical matters that need to be attended to, and have no difficulty with that being circulated more widely. Disclosure of documents. On Tuesday the 11th of December, we met with Counsel for the petitioner, Alex Salmond's lawyers, to discuss their specification of documents, with a view to narrowing the scope of any order to be sought. In the course of that meeting, Counsel for the petitioner were told that the redactions made to documents already disclosed had been made on the instruction of junior counsel for the respondents, that is, the Scottish Government. We understood that to be the case. On Wednesday the 12th of December, in the course of preparation for the hearing fixed for the 14th of December, junior counsel identified a redaction that had not been instructed by her. The document redacted was an email chain involving Nicky Richards, redacted, and Gillian Russell. 2 emails in the chain had been copied to a redacted. We understand that the inclusion of redacted in the email chain was an error arising out of a predictive email address function. Redacted intended to copy in Nicky Richards, but redacted was copied instead. Redacted is a former colleague of redacted. Instead of the unredacted email being supplied to the petitioner's agents, Mr. Salmond's legal team, and an explanation being provided for the error, the email was redacted. The petitioner's agents, Alex Salmond's lawyers, subsequently sought an explanation for the redaction, and they were told that the email had been sent to a recipient in error. The issue had not been specifically flagged with counsel at the time of original disclosure, or subsequently, albeit junior counsel had been copied into a draft of an email to the petitioner's agents that answered a long list of queries about redacted documents, and which made reference to an email having been wrongly addressed. When this issue was identified, on Wednesday the 12th of December, an immediate and clear direction was given that the unredacted email should be disclosed to the petitioner's agents, Alex Salmond's lawyers, in advance of the hearing on Friday the 14th of December. It was intended that the disclosure should be made at the same time as a small number of additional documents, identified in the course of further searches, and including an email that we had not previously seen from Ms. A to the Permanent Secretary of the 3rd of November, indicating support for the Permanent Secretary's announcement of the review of harassment policies and expressing views on the content of that review, were also to be disclosed. Disclosure was thought to be essential not only on grounds of candour, but to try to defuse what we feared would be the reaction of the petitioner to the unredacted email. It is an email chain in which Gillian Russell asks questions of Judith Mackinnon about the circumstances in which complaints of harassment should be reported to the police, and is in the context of wider exchanges about the developing policy for handling complaints against ministers and former ministers. We were, and remain, concerned that it will add fuel to the fire of the petitioner's conspiracy theory. We were both committed to other matters on Thursday the 13th of December, junior counsel being engaged in a debate in another matter for the Scottish Government. On the evening of the 13th of December, having reviewed emails that had been sent in the course of the day, junior counsel asked for confirmation that, as it appeared, the unredacted email had not been disclosed. That confirmation was given, together with an explanation that there was a concern about the GDPR data protection implications of releasing an email with an addressee outside of the Scottish Government. No advice had been sought from us about this issue, and we had not been told proactively about the non-disclosure. After considerable discussion on Friday morning, we reached the view that we could not properly advise the court that the Scottish Government had discharged its duty of candour. We sought and received instructions that the motion for commission and diligence, or discovery, should be conceded. In advance of the hearing, and in an effort to minimise any damaging comment that might be made by counsel for the petitioner, we disclosed the unredacted email to counsel for the petitioners, tendered the explanation that had been given to us about the error, and agreed to lead in the hearing. That is, to speak about the matter. In the event, senior counsel for the petitioner did not make reference in open court to the further disclosure. However, in relation to the motion more generally, senior counsel for the respondents, that is the Scottish Government's lawyer writing this memo, felt bound to make the early concession that the petitioner, Alex Salmond, was justifiably able to say that he was not satisfied that searches are exhausted. Lord Pentland asked senior counsel for the petitioner whether the petitioner's concern that, essentially for whatever reason, the Scottish Government may not have carried out an entirely comprehensive search of any possible place where documents may be held. Presumably the rest of the sentence was intended to read, was still held. Senior counsel for the petitioner, of course, concurred. It is envisaged that there will be an open commission, that is discovery process, in the course of the week of the 17th of December. We trust it will be obvious why this matter has given rise to such concern on our part about our ability to continue to act, that is to represent the Scottish Government in this case. Assurances had been given on a counsel-to-counsel basis, lawyer to lawyer, about the reasons for redaction of documents. Counsel for the petitioner withdrew their application to have the Commissioner consider redactions that had been made on grounds of legal privilege because they were prepared to accept the assurances given that such redactions had been made on the instruction of junior counsel. Having identified that the assurances that had been given required qualification, in other words, that the Scottish Government's lawyers would have to say to the court, we have to come back at you on that, we expected that our direction as to disclosure of the unredacted email would have been acted on timelessly, Scott's legal term for rapidly. That it was not so disclosed left us in an extremely difficult position professionally. The way in which this has been dealt with has also been damaging to the respondents' interests, that is the Scottish Government's own interests. It is clear that the Lord Ordinary, the presiding judge, is unimpressed at being faced with a situation in which it appears that the Scottish Government has not acted with full candour, and in which a commissioner has had to be appointed, that is to oversee discovery of documents. It seems inevitable that parties will now be put to expense and inconvenience of a commission. It is not yet clear whether the petitioner will accept the presence at that commission of a senior civil servant, such as redacted, rather than, for example, the Permanent Secretary herself, as was adverted to by senior counsel for the petitioner as a possibility. In other words, Alex Salmond's lawyers said, can't Leslie Evans herself be at the discovery process? All of this is extremely frustrating because it seems to us it was entirely avoidable. Had the email been disclosed in full at the outset, any questions about the circumstances in which the error was made could have been addressed at that time. New heading: The Permanent Secretary. As was discussed at the consultation on Monday the 10th of November, the petitioner's most recent adjustments have introduced a case of apparent bias against the Permanent Secretary based on her knowledge in November and December 2017 of the complaints being made by Ms A and Ms B, and her knowledge of the involvement of Judith Mackinnon in the management of those complaints. We had understood from the consultation that a full statement was to be taken from the Permanent Secretary to allow those adjustments to be answered. After the consultation, junior counsel indicated to those instructing us that the Permanent Secretary should, in particular, be taken through the documents that had been disclosed and that indicated knowledge on her part. In other words, that the lawyers would say, "Now, Leslie, what do you know about this?" Junior counsel asked for that statement to be available by the morning of Thursday the 13th of December at the latest, to enable adjustments to be prepared and intimated in the course of Thursday. By email, around noon on Thursday, we received a note concerning the Permanent Secretary's position. It was not a precognition, that is, a statement of evidence to be given. It comprises 4 short paragraphs, and it is not clear to us that it is in the Permanent Secretary's own words. In other words, the lawyers are saying politely, we don't think Leslie wrote this. Junior counsel prepared very limited adjustments for intimation. They do not, in our view, answer fully the issue of apparent bias put by the petitioner, Alex Salmond, in his pleadings. The respondent's position on record, that is the Scottish Government's written evidence, is weaker than it might be. It is not clear to us why a full precognition has not been taken. We have the advantage that the court has allowed further adjustment of the petition and answers until the week before the substantive hearing, and so further adjustment is possible. However, it ought to be possible for us to put the Permanent Secretary's position fully and clearly in early course. We would wish to have the precognition previously discussed. As with the disclosure of documents, the approach to this aspect of matters is making it unnecessarily difficult for us to put the respondent's best foot forward. In other words, to do a good job representing the Scottish Government. New heading: Resources. We hesitate to raise matters that are not properly our province. We are concerned, however, that the difficulties that have arisen, particularly but not exclusively in the last week, have been contributed to by limitations on the resources available for management of the case at solicitor level. In other words, the Scottish Government's lawyers are suggesting that their internal legal advisers are not giving this the attention they should. We would emphasise that this is not intended as a criticism of any individual, and hence our desire to limit the circulation of this note. We are conscious that there is one principal solicitor, senior legal adviser, with responsibility for management of the case. Redacted was previously supported by a second solicitor, redacted, but we understand that that solicitor is redacted. It seems clear to us that the further preparations that will be needed, particularly in the organisation of documents, requires additional resource dedicated to this case. New heading: The petitioner's approach to the hearing. It has become increasingly clear that the approach of the petitioner, Alex Salmond, in this matter is one which may appropriately be described as a scorched earth one. It is clear that there is no concern on his part as to who might be criticised or harmed as a result of these proceedings. We understand that this is well understood by those in the crosshairs, most obviously the Permanent Secretary and the First Minister. If instructions are to proceed notwithstanding, then so be it. We are not in a position where we are professionally unable to mount a defence, because, for example, there is no stateable defence. We are, however, perilously close to such a situation. We are firmly of the view that at least one of the challenges mounted by the petitioner will be successful. We are told that there are other aspects to the case which justify the running of the defence, and that accordingly there is no prospect of the petition being conceded, the Scottish Government giving up the case. That decision is not for us to take, and as long as informed consent is given, the decision to proceed is one which we must obey. We are, however, entirely unconvinced as to what benefit might arise from the hearing in January that might outweigh the potentially disastrous repercussions thereof. Leaving aside the large expenses bill that would inevitably arise, the lawyers are of course referring to taxpayer funds, the personal and political fallout of an adverse decision, especially if, as may be the case, it is attended by or accompanied by judicial criticism, seems to us to be something which eclipses by some way the possibility of helpful judicial comments. That being so, and recognising as we do that the wider political picture is something that others are far better placed than we are to comment upon, we cannot let pass uncritically the suggestion that the petition cannot be conceded. A lawyerly way of saying, now come on, are you really unable to drop the case? It would be possible simply to accept, as is our genuine advice as a matter of law, that the appointment of Judith Mackinnon as investigating officer was, whilst made in bona fide, on reflection indefensible. That would render nugatory, in other words obsolete, all of the other potentially more harmful aspects to the challenge. Accepting that a technical error was made could not sensibly be criticised, meaning by Alex Salmond. This would protect those that might otherwise be harmed by the vigorous nature of the challenge that is to be mounted. It would stem the substantial expenses bill that we have no doubt is presently being incurred. Given that we genuinely cannot see the defence prevailing in any event, that seems to us to be the only sensible approach. In other words, the Scottish Government lawyers are saying as of the 17th of December there is no prospect of winning this case. We are acutely aware that much of this has already been said and discounted. The decision to proceed has been taken by very experienced legal and political minds who are entitled to proceed as they wish. However, we are, independently but also mutually, unable to see that the benefits in proceeding come close to meeting the potential detriments in so doing. Given the potential for harm, we simply wish all concerned, and we include the First Minister in this, Nicola Sturgeon, to be absolutely certain that they wish us to plough on regardless, notwithstanding the concerns which we have outlined. Signed, Roddy Dunlop and Christine O'Neill. 19th of December. We write further to recent events. With regret, our dismay at this case deepens yet further. We will not rehearse the regrettable way in which document disclosure has unfolded. Suffice to say that we have each experienced extreme professional embarrassment as a result of assurances which we have given both to our opponents and to the court, which assurances have been given on instructions, turning out to be false as a result of the revelation of further documents, highly relevant yet undisclosed. We, of course, required to consult at 9:15 p.m. last night to discuss the ramifications thereof. This morning, the first part of the commission, or discovery process, began. The inevitable result of the last-minute disclosure of the additional documents was that the commission required to be adjourned. The havers now cited, or those now subpoenaed as being in possession of documents, the havers now cited for Friday can expect a torrid time in the witness box, given the late disclosures. That comment applies in particular to the investigating officer, Judith Mackinnon, for the reasons which follow. All of that is bad enough. However, it pales beside the revelation in the course of this morning of two further documents. These give rise to the same two concerns discussed in the consultation last night, the late nature of their revelation and their content. Each document comes from the investigating officer, Judith Mackinnon. As to the late nature of the revelation, this is unexplained and, frankly, inexplicable. Given the nature of the searches described by redacted as having been undertaken, we regret that we simply cannot understand why these documents have been made available only now. The investigating officer should be warned that she will be pressed on why these documents, and indeed the OneNote extracts provided yesterday, were not both discovered and disclosed long before now. As to their content, the two documents now made available cause us both a real concern. The first is a letter from the investigating officer, Judith Mackinnon, to Ms. A. It is dated the 17th of January 2018. It begins as follows, quote, "We met on the 16th of January 2018 to discuss your experience about the alleged misconduct of a former minister. Following this meeting, you submitted a formal written complaint. I have been designated the investigating officer. The purpose of this letter is to invite you to a meeting to discuss your complaint in more detail. As you have indicated your availability, the meeting will take place on the 17th of January 2018 at 2 p.m. End quote. This letter gives rise to various concerns, which we set out on an escalating basis, as follows. As the letter is dated the same day as the meeting, this must have been sent by email. Where is the email? This letter suggests that there must have been other communications with Ms. A in advance of the meeting of the 16th of January, or how would the meeting have been arranged? No documents in this regard have been forthcoming. It will be recalled that following Ms. A's submission of the complaint on the 16th of January 2018 at 12:19 p.m, the investigating officer was appointed as such by email of the same date at 12:45 p.m. The email reads as follows. I have received this formal complaint from Ms. A and I am appointing you as the senior investigating officer. Would you be able to review this and get the investigation underway? I have thanked Ms. A and said you will be in touch. End quote. There is little doubt that it will be contended, i.e. by Alex Salmond, that this email is disingenuous in suggesting that the complaint will be news to the investigating officer, Judith Mackinnon. We have certainly presented it in that way. In other words, the lawyers are saying the Scottish Government is arguing something that is laughable. This revelation causes acute difficulties regarding the way in which we have, again on instructions, lawyerly language for as you told us to do, pled this case. Looking to the record as it stands, the petitioner avers, that is Alex Salmond's sworn statement is, Ms. A emailed the investigating officer on the 19th of December 2017 informing her that she was minded to pursue a formal complaint against the petitioner, Alex Salmond. The complainer requested a meeting to discuss the practicalities of this. The respondents, the Scottish Government, are called upon to aver, make a sworn statement, whether, and if so, when, that meeting took place, and if it did, what was discussed and or agreed. The respondents are called upon to aver the full extent of the investigating officer's, Judith Mackinnon's, involvement prior to her appointment. End quote from Salmond's statements. On instructions, continue the Scottish Government's lawyers, we have answered those averments as follows. Quote, the investigating officer emailed Ms. A on the 19th of December 2017 in response to queries raised by her about the implications of making a complaint. That email is produced, meaning has been submitted in evidence. There was no further meeting with Ms. A prior to the 16th of January 2018 when she made her formal complaint. End of quote. We cannot suggest that the highlighted averment in the answers, that is the stressed final statement just read, discloses a meeting on the 16th of January before the complaint was submitted. That is not what the averment says. Rather, in order to address the complaint of prior involvement, we have averred that there was no further meeting with Ms. A before she made her complaint. That is, it would now appear, plainly and demonstrably untrue. We have been given 2 draft affidavits from the investigating officer, that is, statements that Judith Mackinnon is proposing to make to the court. Mercifully, neither has yet been lodged. The first, 13th of December, contains the following, quote, on the 16th of January 2018, Ms. Richards emailed me to inform me that she had received an official complaint from Ms A with the written complaint attached. In the email, she stated that she was appointing me investigating officer. She informed me that she had told Ms A that I had been appointed investigating officer and that I would be in touch. I contacted Ms A to arrange the next steps." End quote. The lack of any mention of the meeting of the 16th of January 2018 in what is meant to be a sworn affidavit for use in court is frankly alarming. The next paragraph of the Scottish Government's lawyer's note is redacted. This letter indicates that the prospective investigating officer — there could be no actual investigating officer until a complaint was made — met with Ms A immediately before the complaint was submitted, and that immediately thereafter the prospective investigating officer, Judith Mackinnon, was made the actual investigating officer to investigate the complaint she had just met with Ms A to discuss. We trust that we do not need to say any more about how that appears. The second document now disclosed is an email chain, some of which has been seen before. It starts with the investigating officer's email to Ms B of the 8th of December 2017, setting out her options. There is next the email of the 24th of January 2018 at 1:56 p.m. from Ms B to the IO, making her complaint. Thus far we have seen these emails. What is yet more alarming, however, is what follows in the email chain. By response of the same date at 2:23 p.m, i.e. less than half an hour later, the investigating officer responds saying that she has redacted and will be meeting her the following day. Allowing for a need for haste, questions will inevitably arise from this. Plainly, there must have been further contact, undocumented, in which the investigating officer agreed to meet Ms B. It is unclear whether this preceded or post-dated the making of the complaint. The complaint had only just been made. No one had appointed an investigating officer for this complaint. The investigating officer has effectively appointed herself in that regard. It seems inevitable, unless very prompt action indeed had been taken, redacted, could see Ms B, redacted, before the complaint was actually made, and accordingly before the investigating officer could have had any legitimate interest in speaking to Ms B. All of this gives rise to two concerns. First, we are now in a position where we think that maintaining a defence of the appointment of the investigating officer, Judith Mackinnon, may be unstateable, a legal term for not even a case that you can make in court because it's so weak. Given the timescales, we are reluctant to take a final view on this, but there is a real risk that we so conclude. Second, we are each in a position which is, so far as dealings with the other side and the court are concerned, close to untenable. Again, given the timescales, we are reluctant to take a final view on this, but there is a real risk that we so conclude. We are to meet with the Lord Advocate at 4 p.m. This note has been prepared in haste to allow him to consider the same in advance thereof. We will leave further comment to that meeting. Signed, Roddy Dunlop and Christine O'Neill. 21st of December 2018. A message from Junior Counsel for the Scottish Government to the Lord Advocate and the Deputy Solicitor for the Scottish Government, Paul Caquette. Lord Advocate and Paul, I am aware of the discussions overnight between Roddy, Scottish Government's Senior Counsel, and the Lord Advocate. I understand that as part of those discussions, we have been asked to provide a list of work that would require to be undertaken if the case was to be progressed. That list is provided below. It goes without saying that our overall position vis-à-vis the case remains the same. Disclosure. The further searches that are underway within the Scottish Government for relevant documents were explained at the Commission, or discovery process, this morning. In addition, the havers who appeared, those in possession of documents, particularly but not exclusively Judith Mackinnon, gave personal undertakings to search for specific items, which may or may not exist, identified by the petitioner's counsel, identified by Alex Salmond's lawyers. Judith made reference to documents she believes exist, and in one case to a document that she said had already been disclosed, being a note of the meeting she and Nicky Richards had with Ms A on the 5th of December. That is new to us. We have not seen such a note before, and had understood that there was no note of that meeting. It may be that there is confusion in Judith's mind about dates or the like. Judith also said that she had a call with Ms B on the 23rd or 24th of January, prior to the formal complaint being made. That is new information. The petitioner's counsel and the commissioner, overseeing the discovery process, were understandably unhappy with the suggestion that the further search exercise might not be complete until the 7th of January. We think it would be untenable, standing the court's timetable, meaning in view of the court's timetable, for the search exercise to take that length of time. It has been agreed that there will be a further procedural calling of the Commission by telephone at 11 a.m. on Friday the 28th of December. Substantial progress would need to be made between now and then. There was particular concern about the inaccessibility of the electronic files of Nicky Richards and Liz Lloyd, who are out of the country until the 7th and the 8th of January. Undertakings were given to investigate whether access to their material could be achieved meantime. Adjustment. The pleadings require extensive revision to correct inaccuracies and to put more fully the respondent's position, the Scottish Government's position. Corrections include dealing with the erroneous suggestion that there were no further meetings with the complainers after Christmas and in January 2018 prior to them making their formal complaints, and qualifying the averment that Judith's call with Ms B on the 7th of December 2017 did not involve a discussion about the content of her potential complaint. There is, in the note of the telephone call that Paul sent last night, reference to Alex Salmond, redacted. And there is also reference to redacted, which reads as a reference to the complaint that Alex Salmond, redacted, Ms B. The relevant adjustments cannot properly be made without a full precognition, beyond the note version provided last night, from Judith Mackinnon. That is, the lawyers going through the evidence with Judith Mackinnon, including getting to the bottom, if possible, of whether Nicky Richards was also at the meeting on the 16th of January. As mentioned on previous occasions, adjustment is also required to meet the complaint of bias against the Permanent Secretary, Leslie Evans. That would require a comprehensive precognition from the Permanent Secretary, as requested previously. In other words, the Scottish Government's lawyers are saying, why is Leslie Evans refusing to see us? Prospects. It need not be said, but the new information over the last 24 hours about further contact between Judith Mackinnon and the complainers simply reinforces our views about the case in relation to her prior involvement and apparent bias. The note of the call of the 7th of December suggests that Judith had information not only about Ms B's complaints, but had been given a wider picture of a redacted created by Alex Salmond, which might well be such as to impact her ability to be impartial. Regards, Christine. This email was followed up the next day, Saturday the 22nd of December 2018, by Roddy Dunlop, QC, Senior Counsel, who sent the following to Paul Caquette, Deputy Solicitor for the Scottish Government, and another redacted recipient at the Scottish Government. Apologies, but another point occurs to me. There has been some suggestion of calling Judith Mackinnon as a witness to rebut the problems we have regarding bias. In addition to the obvious problem already made that calling her could only ever rebut actual bias and not apparent bias, we now have the further problem of her meeting Ms A on the 16th of January, immediately before Ms A lodged her complaint. The problem with this is that Judith Mackinnon stated in the commission or discovery process yesterday, on oath, that she could not remember that meeting. That leaves us unable to aver, let alone prove, what happened at that meeting, and thus unable to rebut the rather obvious inferences that will otherwise be drawn from the fact that it occurred. If one needed a watershed moment where the case moved from very difficult to unstateable, that was it. Given the amount of work ongoing, I must urge that a view be taken thereon as soon as is possible. In other words, come on, decide whether you're going to drop this case. Continuing to rest on pleadings that we know to be untrue is liable to result in severe judicial criticism. With repeated apologies at delivering further unwelcome advice, and with a further entreaty that urgent instructions be obtained in light thereof, I wish all of you a merry festive season. Best, Roddy Dunlop, QC. 29th of December 2018. A long memo with annexes from Sarah Davidson, Director General of the Scottish Government's Organisational Development and Operations Division, to the Permanent Secretary Leslie Evans, with copies to Ken Thompson, Director General for Constitution and External Affairs, the Director of Legal Services, the Chief Financial Officer, and the Director, Communications, Facilities and Ministerial Support, or at the Scottish Government. I shall read only the top and tail of this long memo, which is entitled Judicial Review, Next Steps. You asked me to coordinate the provision of urgent advice in order to allow you, Leslie Evans, to consider how to proceed in relation to the judicial review which is set down to commence before Lord Pentland in the Court of Session, Scotland's highest civil court, on January the 15th. In doing so, I have drawn heavily on contributions from the Director of Legal Services, who has, in turn, consulted on key points with Counsel and the Lord Advocate, from the Chief Financial Officer, and from the Director of Communications, Facilities and Ministerial Support. I am grateful to them all for responding so promptly to this request. The memo continues to review Counsel's advice, and in that section Sarah Davidson writes that Counsel and the Scottish Government's internal legal advisers, the Director of Legal Services and the Lord Advocate, share Counsel's view that the case should be dropped. New heading, Conceding the Petition. If a decision is taken to concede the petition, or give up contesting Alex Salmond's civil case, the process would involve a counsel-to-counsel or lawyer-to-lawyer discussion of the Scottish Government's offer to Alex Salmond for compensation and the best and most efficient way of achieving settlement, with a view to agreeing a joint minute setting out the basis of conceding and appropriate declarators, Scots legal term for legal declarations, making clear what is and what is not the basis of the concession, and agreeing expenses. In parallel, the court would be advised of the Scottish Government's decision not to proceed with our defence on the basis that there were ongoing discussions about disposal. How to wrap the matter up. In such circumstances, the decision which was being judicially reviewed would be set aside and referred back to the decision maker. In other words, Alex Salmond would be cleared from the internal Scottish civil service case against him as a former minister, and the matter would be sent back to the civil service. In this case, for a range of reasons, not least the views of the complainers about going through the process again, consideration needs to be given to whether the Scottish Government could restart and rerun the procedure and ensure fairness. The petitioner, Alex Salmond, may look for assurances that this will not happen, but it is premature to decide or indicate whether and how this would happen, and the views of the complainers would of course be something you would want to take into account. Legal advice is that it is unlikely that the Scottish Government would be able to formally withdraw from the court case without conceding flaws in the application of the procedure in this particular case. The petition contains a number of pleas in law, most of which the Scottish Government would not be conceding. However, I am advised that we would need to concede all or part of 2 of the pleas in law, as part of the formal disposal by the court. These are as follows. The section in square brackets might be argued out by counsel. The decision having proceeded on an error of law by the first respondent, decrees of declaratory and reduction, or setting aside the decision by the civil service, should be pronounced, and the decision of being irrational and separately unlawful as a result of the application of unfair procedures and being tainted with bias, square brackets, and being in breach of the petitioner's Article 6 European Convention on Human Rights, square brackets end, decrees of declaratory and reduction should be pronounced. While we will simply be indicating a decision to concede when announced, the terms of disposal by the court will be adjusted by counsel in the days ahead, in a joint minute, and we will seek to narrow the terms to the minimum of conceding that the decision cannot legally stand and is set aside, and, as above, the pleas in law which the court will uphold in doing so. In other words, to salvage what can be salvaged of the Scottish Government's position. We would not be negotiating in any way about future decisions. If the joint minute cannot be agreed, the court will itself make an order to the same effect. In handling terms, once a decision has been taken, it would be beneficial to intimate the concession as soon as practicably possible following the events of last week. The Scottish Government's Legal Directorate advised that it would be essential for the court to be told at the same time as the petitioner's counsel, Alex Salmond's lawyers, and it should be possible to get a message to Lord Pentland next week. This would be easier on Monday or Thursday when the court is open, but might still be possible, although less straightforward, on Tuesday or Wednesday when the court is closed. The court would not look favourably on any public statement being made before Lord Pentland was advised of the position. We now skip sections which foresee the implications of conceding in terms of what Alex Salmond might say and do when he wins his case, and in terms of the Scottish Government being able to account for the spending of taxpayers' money, in continuing to pursue resisting Alex Salmond's case so long. Sarah Davidson concludes, having reviewed the material contained in this note, you may conclude, this is senior Mandarin speak for you jolly well ought to, that the Scottish Government is in a position where the only sensible and defensible action is to concede the petition, or give up the case, and to plan for managing the attendant reputation and legal risks. The risks associated with proceeding to defend the judicial review could appear to be greater. I hope that this advice provides you with the necessary basis on which a formal decision to concede on the terms set out above can be reached. Colleagues and I stand ready to discuss any aspect of this note. Signed, Sarah Davidson, Director General, Organisational Development and Operations, Scottish Government. Annex A to this document indicates in an interesting table that the Scottish Government's external counsel and internal legal experts, including the Lord Advocate, disagreed on only one of several issues with regards to the winnability of the case, namely the issue of whether or not Judith Mackinnon had had prior involvement in any aspect of the matter before being appointed investigating officer against Alex Salmond. On this regard, the summary of the position by Sarah Davidson in the annex is that after the 31st of October 2018, the Scottish Government's external counsel took the view of being concerned that the Scottish Government's arguments were more likely to fail than to succeed, but were stateable, in other words, a valid case could be made, while the Scottish Government's legal directorate and the Lord Advocate took the view on this point of, quote, while understanding risks, there were good arguments supporting the Scottish Government interpretation on a natural reading of the procedure, namely the civil service procedure under which Alex Salmond had been found guilty. At the end of Annex A comes a statement of the timeline of the case, which is entirely a reflection of the pieces previously read out in this recording, except that the final item in the timeline is not reflected there. It is the chronology entry for the 28th of December 2018 and reads, Junior counsel indicate, and it seems clear that senior concurs, that is Mr. Dunlop, that in light of their professional duties and their view of the case, they will require to withdraw from acting, that is for the Scottish Government in this matter, on the 3rd of January if matters are not resolved by then. Sarah Davidson's remaining annexes, B and C, consider respectively the considerations on spending public money properly and what balance of evaluation should be made there, and a timeline of how to end the judicial review. The final document disclosed by the Scottish Government with regard to this judicial review is dated the 31st of December 2018 and is a heavily redacted email chain, in the middle of which comes the following email sent by the Lord Advocate, James Wolfe, to redacted recipients, including Paul Caquette, the Scottish Government's Deputy Solicitor. Subject: Alex Salmond versus the Scottish Ministers. Draft Statement. With a view to effective handling, it seems to me the concession should be narrowly framed to reflect accurately and carefully the legal basis upon which ministers are conceding the petition or giving up the case, and the basis of the concession should be explained as fully as it can be. It may be unlikely that it will be possible to avoid the phrase apparent bias being used at all in all communications, including with the court. However, the use of that phrase should, in my view, be minimised, and should always be coupled with an appropriate explanation, intelligible to a layperson, of what that means, i.e. that the process, civil service process, must be seen to be impartial as well as actually impartial, and what it does not mean, i.e. that the process was actually tainted by bias. It also seems to me that it may be helpful to reflect that the legal conclusion is based on a review of the case in light of all the information now available, including the documents which were recently disclosed, and that government, the Scottish Government, always keeps any litigation under review in light of the case as it develops, and that is what has happened here. It is for the Scottish Government to decide on what basis it is prepared to concede the petition, or give up the case. As I understand it, the Scottish Government will concede that the decision should be reduced, or legally set aside, and it would be appropriate for the Scottish Government also to invite the court to pronounce a declarator, or legal declaration, in appropriate terms which would support reduction, or setting aside. Counsel's input will be necessary on the terms of the declarator, but I envisage that this could be along the lines of the following, that Having regard to the totality of the investigating officers, Judith Mackinnon's dealings with the complainers before her appointment, the reasonable observer would conclude that there was a real possibility that she could not act impartially, as she was required to do by the procedure. If the Scottish Government proposes to concede reduction, accept that its finding against Alex Salmond should be set aside, it is not clear to me, James Wolfe, subject to Counsel's advice, that it would be necessary to enter into a joint minute. Certainly it is not for the petitioner, Alex Salmond, to dictate the basis upon which the Scottish Government concedes. No doubt it is possible that the petitioner could say that he would like the petition to continue, notwithstanding the concession, so that his other challenges could be adjudicated on. And such a position might be supported on the basis that ministers are reserving the right to reconsider the matter once the police inquiries are at an end. Whether to accede to such a position would ultimately, in the absence of agreement, be for the court, and the Scottish Government might be quite happy with the petition continuing to provide the clarity which ministers have hitherto thought was useful. However, I would be very surprised if the court would entertain the proceedings continuing to challenge a decision where the minister proposed to concede was flawed. The end of that sentence by James Wolfe, Lord Advocate, is grammatically ambiguous. It would be useful to have Counsel's input on these matters before the decision goes live, and ideally before final decisions are made on handling by the Scottish Government in PR terms, though I appreciate that the intervention of the holiday, Hogmanay, makes that difficult. End of Lord Advocate's email of New Year's Eve 2018. This was forwarded that same afternoon, New Year's Eve, by a redacted person at the Scottish Government to redacted recipients in the Scottish Government, including Sarah Davison. The email forwarding the Lord Advocate's email states, "Please see the below from the Lord Advocate," which is his response on getting as much precision on the terms of the concession as we can, consistent with the note to the Permanent Secretary and the developing statement, capital S. See in particular the end of the Lord Advocate's email and the suggestion at the end of 4, that is the point, the reasonable observer would conclude that there was a real possibility that Judith Mackinnon could not act impartially. The forwarding email continues, "This, to me, matches the intended statement, capital S, sufficiently closely." As discussed earlier, the precise wording will need to be worked up, but it is helpful to see Lord Advocate's confirmation that we do the deciding if needs be. The pinch point in the below ties in with when Counsel, the Scottish Government's legal advisers, are asked for a view on what to say. I take the point made by the Lord Advocate, but if our own discussions with Counsel are essential before the decision goes live, I cannot see that being resolved in time for noon on Thursday. This is not least because a final basis for disposal, court settlement, will need either agreement with the other side, which by definition must wait until after we go live, or a direction by the Lord Advocate telling our Counsel, since I can't see them fitting in with what we need in the requisite timescale. I'm happy to go back to the Lord Advocate and say that. Meantime, subject to handling of Counsel, in other words the Scottish Government dealing with its own lawyers, in the period ahead, we now have from the Lord Advocate a steer on the concession and how it would look. Redacted section. Possibly just the name of the person signing off. P.S. I gather that there was some discussion just now on Alex Salmond continuing, that is, his civil case in the Judicial Review after this concession. The Lord Advocate and I discussed that on Saturday, and he thought that, in the face of us saying the decision letter can't be sustained, the court would have no basis to contemplate continuing, and is unlikely to entertain such a suggestion. The decision letter referred to here is the formal notification by the Scottish Government to Alex Salmond that he had been found against in the internal complaint procedure. And finally, in what is visible in this disclosure from New Year's Eve 2018, is another New Year's Eve email sent on behalf of the Permanent Secretary Leslie Evans by a redacted underling to Sarah Davidson regarding her advice of the 29th of December, previously read out in this recording, on how to wind up the matter. The underling replies on behalf of Leslie Evans, Permanent Secretary: Sarah and Paul will be Paul Caquette, the Scottish Government's Deputy Solicitor. The Permanent Secretary, Leslie Evans, is considering the attached advice. She would be grateful for further advice from the Scottish Government's Legal Directorate during the course of today on the specific nature and basis on which any concession may be made. I have included redacted, given Paul is out of the country. The two separate items dated New Year's Eve 2018 that were just read out constituted Attachment 2 and Attachment 3 to a covering email or document. That covering email or document, 1 page long, is blank in the disclosure because entirely redacted, and Attachment 1 is also blank in the disclosure because entirely redacted.